I've been helping expats and high net wealth individuals now for over 10 years. In that time, I've regularly been featured in the media, including on CNBC. I've written a book about expat investing. I've interviewed the Shark Tank judge Kevin O'Leary, and I've got the largest social media following in my niche globally, including on Quora.com. In that time, I've found some commonalities in terms of what I'm asked online and offline. Primarily for wealthier people, asset confidentiality, trusts, and foundations are something that people ask a lot of questions about. So I've interviewed many experts on this topic. So in the following video, you're going to see highlights of my interview with an expert on creating trust in Singapore, including for non-Singaporean residents. You're also going to hear from Mark Morris, who has consulted for the OECD, the EU Parliament, the German Parliament, and many others. And he's considered one of the leading experts globally on international tax agreements. You're also going to hear from an American tax expert who focuses on matters related to Americans or people who have American assets. So this video is for people who are interested in asset confidentiality, also succession planning, in other words, passing down assets to your children efficiently, especially if you've got assets across borders. As a reminder, this is not formal legal or financial advice. This is for entertainment and informational purposes only. If you do want to get in contact with me, reach out on the details below. You mentioned, say, FATCA, which obviously cause a lot of issues for Americans living overseas. In very simple terms, how would you explain FATCA for, say, an American who's about to go overseas?
Well, I think FATCA has many different implications, but I think in terms of an American that's about to go overseas, the main implication of FATCA is that FATCA requires foreign banks and other financial institutions to report the accounts of U.S. persons, so citizens, green card holders, to the United States. And so, basically, if you have an American that moves overseas and let's say they're living in Austria and they have a bank account there, the Austrian banks are going to report that information through the Austrian government to the IRS.
And what's interesting about this rule was I noticed when it first came in, and I was living in Southeast Asia at the time, many banks, insurance companies, and other financial institutions just refused to take Americans any longer because they thought this is too much hassle, right? Not all of them, but a lot of Americans, I think, got debanked or their platforms or brokerage accounts just said, we don't want to deal with you anymore. But fortunately, there are companies that do accept Americans, but it's much fewer than before this rule, I think.
Well, I think my experience has been maybe a little bit different. I think my experience has been, I think as you very correctly state, as FATCA first came out, most, or not most, but a lot of banks just decided we're not doing business with Americans. This is done, right? I think what I've seen happen over the years, though, is that most banks now that FATCA is kind of settled and there's people out there that really understand it, I feel like the banks feel like there's a little bit more certainty around it, and so I think most banks will now accept American clients if the American is resident in the country where they're trying to open up a bank account. So if you use Singapore, for example, I think if an American now just tries to go open a bank account in Singapore, probably not going to work. But if the American is resident in Singapore, then probably they're going to get an account. I mean, what I've seen is that I think you still have a lot of sort of private banks and wealth management banks that very much do stay away from Americans, or companies offering brokerage account services. But I think most banks just offering normal banking solutions, I think most of those banks will accept American clients again now, assuming the American's resident in that country.
Absolutely. As you said, I think as well, when it comes to a brokerage investment account, it's much more likely that the institutions didn't accept Americans. But we have noticed ourselves now in the last few years doing what we do in the expat investing space, that more companies are kind of allowing Americans again, I think. But as you say, maybe it's because now the dust has settled a bit. They understand what the rules are. They understand the costs and so on and so forth. But it definitely has added a layer of complexity, hasn't it? Like the PFIC rules as well.
It's also added a layer of cost, right? Because if you, as a non-American, using like a Swiss private bank as an example, go to a Swiss private bank, you can do business directly with the Swiss private bank. But if you're an American, you're going to need a registered investment advisor sort of to act in between the bank and the U.S. person. So it adds a layer of complexity and also a layer of cost.
Absolutely. Now, we just mentioned the PFIC rules as well, right? And a lot of people also get confused about the rule.
Yep.
But my understanding is it can be explained in quite a non-complex way as well. What would you say in kind of broad terms are the PFIC rules? Now, of course, this is not formal tax or legal advice and so on, but what would you say are the basics of it?
I mean, look, so PFIC is generally any sort of foreign company that's generating mostly passive income, right? So interest, dividends, royalties, things like that, right? So the technical definition is a foreign company who I think there's more than 75% of its income is passive, so interest, dividends, things like that, or more than 50% of its assets produce or are held for the production of passive income. And that's something where people get tripped up quite a bit, right? Is if you have a company that's actually, let's say at the moment, not generating any income, but it's sitting on a large amount of cash, cash is held potentially for the production of passive income. So it would be a PFIC just by virtue of it having a lot of cash and no other income. But the main downside, so I mean, when you think about PFICs, I mean, the easiest way and the most common way to think about a PFIC, if you're investing in some sort of a non-US fund, a mutual fund, any kind of investment fund, that's generally going to be a PFIC. And the downside to a PFIC is when you sell it, and most kinds of distributions, which they define as excess distributions, but if you receive a distribution from a PFIC or if you sell a PFIC, you're generally going to have a punitive tax, which is essentially you have to take the gain or the distribution and divide it up over the holding period that you've had it, and then calculate the tax. Like, so let's say you owned it for 5 years, right? You'd have to calculate tax on the gain in each one of those 5 years at the highest tax rate then in effect, and then apply an interest charge to it as if you should have, because you didn't pay the tax in those years. And by the time you add up all that tax and those interest charges, I mean, oftentimes what you wind up owing will wipe out any of the gain or distribution that you receive.
And if I'm not mistaken, in general terms, if an American, still holds their nationality or they've got a green card for that matter, what you just said means that often it makes sense to still own ETFs and funds domiciled on the New York Stock Exchange. However, secondly, if it's an individual stock or an individual corporate bond, I believe in general, then the PFIC rules don't exist. Is that correct in general?
That's correct. In terms of assuming that individual stock is a company conducting active business, right? Like you own a stock of Mercedes or something like that, where it's an active business, then absolutely. I would say generally that's a correct statement.
Yeah, it's interesting because we're talking to an American today actually and just explaining, well, if you want to buy a foreign ETF, we can technically mirror the index and so on with individual stocks. And, it's interesting how a lot of these rules to the average layman who's not in the financial services industry don't make sense, but it is what it is, right? It's just these tax things can trip you up, right? Because as you said, in some cases, I think the PFIC rules can cost you 30 or 40% pretty much, right?
Well, and I mean, it's not, absolutely, right? And it's not just the tax cost to the PFIC rules either, right? I mean, it's the reporting that you have to do on the PFIC, right? I mean, you have to file Form 8621 if certain criteria are met. And this is something that, a lot of people miss, not because they intend to, but because their tax preparer doesn't know what they're doing, because they're not specialized enough, or they forget to tell their tax preparer that they own this because they don't realize that this needs to be filed. And obviously, besides the penalties for not filing Form 8621, 8621 is one of those forms that will cause the statute of limitations on the tax return to stay open indefinitely, which means, the IRS can come back and audit the tax return 20 years later. Owning PFICs does carry, some financial consequences, negative consequences, as well as some risks associated with the compliance aspect of it.
Sure. Now, circling back to what you do, obviously part of what you do is the tax side for assets, presumably, but I believe you also help business owners who are Americans who may be living in wherever, Dubai or Singapore or Qatar, whatever. So when it comes to, let's say, your American clients, what would you say are like their key 2 or 3 reasons why they reach out to you, and how do you help them in that respect?
So I would say there's probably key 3. So, my background is in U.S. international tax. So, helping Americans navigate the U.S. The international tax landscape when they're doing business or investing abroad. So I think, one of the reasons people reach out to me is they believe or realize that they have a tax problem, that maybe they haven't been reporting everything properly. Maybe they know they haven't been reporting everything properly, and they want to know how they can get back into compliance. Now, I don't do the returns myself, but I can certainly advise them and help them, devise a strategy for getting back into compliance, and then put them in touch with the people that can actually prepare the returns. The second one is, Americans doing business abroad, right? So Americans, we have several here in the UAE, or as you mentioned, in Singapore or in Europe, that own a business, and they want to know the best way to structure that, right? Should they be structuring that as a sole proprietorship, as a corporation, as a partnership? What are the tax consequences of the different ways of structuring, and what's going to be most advantageous to them, right? And so helping them figuring out what that structure is and which is going to be most advantageous to them from a U.S. tax standpoint, as well as a local standpoint where they're doing business. And then thirdly, I think the third reason is, I think there's a lot of mixed families where you have some people that are U.S., some people that are non-U.S. So as an example, a very typical situation that I run across is, a father that is not a U.S. person who's generated the wealth and made the money. You have a wife, the spouse, who's a non-U.S. person, who is a U.S. person, and because of that, the kids are U.S. persons. And then how do you do the estate planning for that, right? Because obviously the father's generated all this wealth, doesn't necessarily just want to leave it to his wife and kids and then subject it to full U.S. taxation and reporting and all of that stuff. And so a lot of, how do we structure that estate, make sure the assets are protected, make sure that the U.S. heirs get the benefit of it, but without subjecting everything to U.S. tax and reporting.
Sure. Now, this gets very complicated, of course, if it's multi-jurisdiction. So
certainly,
and obviously everyone's situation is a bit different, right? Because it does depend on also where they're resident, I guess, and many factors, right? Yep. But I think when we were talking before, you were also saying that you also deal with non-Americans as well when it comes to estate planning, yep. Right? But I guess practically speaking, for Americans, there are other factors, right? Because for Americans, renouncing, your passport is an option. Well, it's an option for everyone globally or in most countries. But I think with the US side, it's become a bigger thing, right? It's kind of ironic that like so many people want American passports globally, but then a lot of wealthy people get rid of it. Like the guy who started Facebook with Zuckerberg, Edward Swarin, I think his name is. So what about in this case? Do you help with renunciation?
Absolutely.
Who do you think should consider it as well?
Well, I think there's so we do absolutely help with renunciation, and there's when you talk about renunciation, renunciation we call expatriating, and there's essentially you can be categorized one of two ways, as a non-covered expatriate or a covered expatriate. Non-covered expatriate means you can basically expatriate and you become like every other foreigner, and you have no tax consequences, no exit tax, no nothing. If you're a covered expatriate, then you're subject to an exit tax, which is basically a mark-to-market tax on your unrealized gains. And any deferred compensation items, like let's say, for example, retirement accounts, generally being subject to tax as if you received all the income in the year of expatriation. But probably the most devastating thing for covered expatriates is if they give any gifts or leave any inheritances to U.S. persons, those U.S. persons are going to be subject to the highest gift or estate tax then in effect, right? And so that makes it pretty devastating if you have a wealthy person that expatriates, but maybe their kids are still American. If they leave an inheritance to those kids, the kids, rather than the estate of the covered expatriate, are going to be liable for the estate tax. So to be considered a covered expatriate, you have to have a net worth of $2 million or more, or paid an average income tax of, I think it's $191,000, or not be tax compliant, and that would trigger you to be a covered expatriate. So in terms of, who should consider expatriation, I think certainly accidental Americans, right, who are American because one of their parents was American or they happen to be born in the U.S. but really have no connection with the U.S. If they don't plan on keeping a connection with the U.S., if they don't plan on living in the U.S., then obviously keeping the U.S. passport is not giving them a lot of benefit unless their other passport is not a very good passport, right? And they're not to call anybody out, but for example, if you have an Indian passport or a Chinese passport or some passport that's difficult to travel on, then a lot of times it makes sense to keep the U.S. passport even because of the tax, just as a travel document. But assuming you have a strong second passport, you're an accidental American and you don't ever plan on living or working in the U.S., then you're not really getting any benefit from this passport. I would strongly consider expatriating. Likewise, if you're an American that's moved abroad and you've been abroad for quite a while, you have a strong second passport, and you're never planning on moving back to the U.S. or living in the U.S., then probably the passport's not doing you a lot of good and is only causing you, downsides. I would consider expatriating.
Sure. Now, what's interesting, you mentioned about the accidental Americans. One funny case I heard about was the former UK Prime Minister Boris Johnson.
Yep.
And he was born in the United States. I'm not sure if one of his parents was American. I think they're both British, but he was born there.
Yep.
So he had a second passport, but he was furious after the IRS kind of gave him a tax bill.
Yep.
And eventually he settled it, I think, but then he renounced after settling, right?
Yep.
So I think that was one of the more high profile cases, right? But I'm sure there's been many like that, right?
I think with Boris Johnson, I think, obviously because he was a high profile person, he was sort of in the IRS's crosshairs. I think most accidental Americans never actually get in the IRS's crosshairs, right? I think most accidental Americans get into compliance for fear of the IRS, but not because the IRS has contacted them or anything like that. I mean, surprisingly enough, FATCA, as we discussed briefly, became law in 2010 and really put a lot of fear into a lot of people, including the accidental Americans, many of whom did wind up renouncing. But what's interesting is, FATCA hasn't really done anything in terms of, it was supposed to be this thing where if you didn't report and you weren't in compliance, it was going to give the IRS the information they needed to come after you. But the fact is, it seems to me and most professionals that I know that all the FATCA information has more or less gone into a black hole, and that the IRS hasn't really done much anything with it.
Well, it's a bit like the CRS at the OECD level, right? So now globally, information is shared.
Yep.
But there's so much information out there. I know obviously if AI, this could change, but you wonder what they're actually doing for this information, right? It's a bit like even when terrorist attacks happen globally, a lot of the time people say, oh, they were on the terrorist watch list or whatever. But I guess the problem with governments now is if they're collecting so much information, what do they actually do with it, right? Because if you think about it, the CRS as well, like FATCA, this is probably even quadrillions piece of information. What do they actually do with it, right? That's one thing.
We don't know, and I think what you said with AI, this could very much change. But I mean, what I've seen so far, and this is a topic that obviously I discuss with colleagues and other professionals. And I mean, what we've seen is basically they're doing nothing with it, right? I mean, it's just essentially going into a black hole. But
data collection,
yeah,
in many cases.
Exactly.
Yeah. Well, it's interesting, but as you say, right, there is obviously a great reason why people should try to be compliant, because you mentioned about Boris Johnson being high profile, but I'm presuming when it comes to, for example, estate taxes and so on, there is an incentive for the tax authorities globally to look at those like bigger cases more carefully, because if you've got someone who dies and they've got $2 million, but then you've got another person who dies and they've got 500 million, the tax authorities surely are more likely to look more carefully at the bigger case, because then, if they succeed, they're going to kind of get more revenue, right? So
100%. I mean, I definitely think, the more high profile something is, especially the more money it involves, it becomes more interesting to the tax authorities. I think the truth of the matter is, though, that, especially in terms of the IRS, I think they're so disorganized and so understaffed that I think a lot of this stuff just falls under the radar, especially on the international side, right? Because within the United States, pretty much everything that happens is there's some sort of form being filed with the IRS, right? Whether it's a 1099 or a W-2 or whatever, there's some sort of document that's going to the IRS about this transaction or about this income, and it's very easy for the IRS to track within the computer system. When a return gets filed, they can sort of match it up and see if there was something unreported. But once you start moving into income and assets that are outside of the United States, that becomes much more difficult for them.
Sure. Now, when it comes to estate planning, do you just look at it from a tax side, or do you also look at it from like a convenience side? Because, for example, if someone was to die, I'm guessing from an emotional point of view, being paid quickly, at least the beneficiary is being paid quickly, that's a massive thing, right? So, for example, some of my clients prefer to go via an insurance company because they know that the insurance company usually pays our beneficiaries more quickly than, say, an investment advisory company or a bank. So do you kind of look at those angles, or do you just look at it from a pure kind of tax point of view?
No, I look at it from a tax point of view. I look at it from also an asset protection point of view, from a privacy point of view, if that's something that's important, and also from an estate planning, as you said, sort of a convenience point of view, right? So most of the estate planning that I do involves setting up a trust or foundation, right? And so I think one of the big benefits of having a trust or foundation is once the assets are moved into a trust or foundation, they no longer belong to the individual. So you get a lot of asset protection, but you can also define how the beneficiaries are to benefit, right? And because the assets, like an investment account, for example, would be held in the name of the trust or foundation, the fact that the person died is somewhat irrelevant, because it's the trust or foundation that holds it, and the people that control the trust or foundation are the ones that decide what's going to happen with the assets in the trust or foundation. So you can still make sure that people have access, the beneficiaries have access to the money quickly. Now, one of the things that you have to consider is, how the person wanted their estate structured. Some people want their estate structured, hey, when I die, I want all the money to go to my spouse, right? And you can define that in a trust or foundation. Or, hey, when I die, I want half to go to my spouse and half to be divided up between my kids. Or you can define that, but that's at a very simple level, right? But when you start talking about larger estates, potentially, 10, 20, 30 million plus, then a lot of times this is enough money that the person doesn't want it to go directly to the beneficiaries all in one go, because they feel like it's going to be too much money and it's not going to be good for the person. And sometimes you look at it from the standpoint that there's enough money that this could support many future generations, right? In which case we want to look at a multi-generational structure where, the investments and other assets are placed into a trust or foundation, and the trustee or the board of directors of the foundation decide which beneficiaries are going to get what and when, right? So a very typical structure for large estates is you'd have a trust or foundation, and the income that's generated by the assets in the foundation would be distributed to the beneficiaries for their support, maintenance, whatever to support them. But the actual principal assets would remain in the trust or foundation essentially indefinitely. And as future generations are born, they would automatically become beneficiaries and could benefit from the income being generated within the trust or foundation. Now, obviously, they could choose to distribute the principal if they wanted to, but generally, they try to make it sort of a thing that's going to exist indefinitely to support multiple generations with the income, but keeping the principal within the structure, within the trust or foundation, because it's protected and will allow the future generations to benefit.
And do you ever set up structures where, for example, you set up an LLC company in conjunction with a trust? Because some of my clients have done things like Cook Islands Trust, because they say that the LLC, the company, can be owned by the trust and they can be the signatory. Have you worked on structures like that as well?
100%. I mean, that's a very typical structure, right? Because typically, whether you set it up in the Cook Islands or somewhere else, I mean, typically you would have the trust, and then a lot of times the trust would own an LLC, which would sort of be like the holding company, right, for the portfolio. And a lot of times what we do is we set up actually multiple LLCs under the trust. So maybe you have one LLC that's for owning the family's real estate. You have one LLC that's for owning the investment portfolio. You have another LLC that's for owning shares potentially in private businesses or private companies. So you sort of try to set up different silos for different asset categories.
Sure. And I guess that includes the primary business as well, because funny thing is, anyone who's watched the drama Succession, right, will know that this can be a major issue, right, for some wealthier families, not just at that billionaire level, but I'm sure there's plenty of people who are a bit older, they've got a lot of money, but they're not billionaires, but they're a bit worried maybe they've got numerous siblings or numerous children, and they think, do I really trust any one individual? So maybe the trust, we could have a board of directors, and that must also be a part of it, right?
You're 100% correct, right? And I mean, this isn't, I mean, a lot of times it doesn't even necessarily have to do with the trust aspect, although that certainly is a consideration, but sometimes it also just has to do with the fact that, you know, many wealthy kids have been fortunate in that they've grown up wealthy, and so they've really been able to choose to study or focus on the things that they're passionate about rather than making money, right? So a lot of times you just have, let's say people that are not versed in financial type things in business, right? I mean, maybe it's an art person or something like this. And so this allows, like you said, to have a board of directors in place that has the necessary skills to administer the trust assets and do the investments and everything necessary to keep growing them and protect them for the benefit of the family and the beneficiaries, obviously.
Sure, absolutely. But I mean, all these structures, obviously, they don't come for free, right?
Of course.
So, and there's different levels of trust, and certain people just need it for their assets, some people for their businesses.
Yep.
I mean, approximately what kind of net wealth level do you think people should be looking at when it comes to the structures that you set up?
So, I mean, look, I think there's a few different categories, right? So you know, we have one trust foundation product that's what I would call it's called the Eternum Trust and Foundation, and it's what I would say is a sort of semi-custom trust or foundation, right? So it's more or less you have a few different options that you can choose from in terms of customization, and then that's it. And that's probably going to be good enough for 80% of the people, right? It's not too complex, but it's going to provide most people with what they need. And I would say that starts to make sense once you have about $1 million in liquid assets. Then that already starts to make sense, right? Because it's not so expensive to set up. And the administration costs on an ongoing basis are manageable. Once you hit about, I would say, 10 million, then you probably want to start looking at something that's now, even if you're at 10 million, if you don't have any, very specific criteria that you want built into the trust or foundation, the semi-custom option is going to be good. But generally around 10 million, people want to start putting in some very specific provisions into the trust or foundation. And then you want to look at sort of setting up a very customized trust or foundation specific for your needs and your family's needs. And once you hit about 25, 30 million, then you're looking at sort of comprehensive multinational estate planning, right? So that's when we get hired to look at, somebody who says, hey, look, these are my assets that I have worldwide. These are, the citizenships and nationalities of my family. Design a structure to own all this stuff, a trust and foundation behind it that's going to be multi-generational and that's going to serve these specific purposes.
Absolutely. That makes a lot of sense. And what was interesting is, I'm guessing as well, even though it's a bit of a thorny issue, for some people, if they're worried about lawsuits, I guess in reality, that is actually one of the many things that maybe prompts them to get these structures out. Now, I understand that obviously it depends on the jurisdiction. Obviously, in certain countries, there's more litigation than others, including the United States, sure. Right? But I'm guessing that is one reason, actually, why people get out these structures as well. They want to separate themselves from their assets, right?
Well, I think that's absolutely right, and I think it goes beyond lawsuits, right? I mean, a lot of times when you talk about wealthy people, or even not so wealthy people, they want to sign prenuptial agreements before they get married, right? But as we've seen in many court cases in the news and stuff like that, prenuptial agreements are not always the strongest. They can be broken for different reasons. I usually advise my clients to put their assets into a trust before they get married. Then they don't even need to talk about the prenuptial agreement in a lot of cases, right? Because the assets are in a trust, they're protected. And you're not only protecting the assets from lawsuits, from your business or from whatever, but you're also protecting it from potential lawsuits of your heirs, right? I mean, if you have kids that are a little bit older and they're beneficiaries of this, and if you were to die and they were to receive these assets outright, if they get sued, the assets are at risk. If they get divorced, the assets are at risk. But if the assets are held within a trust or foundation structure, you're also protecting the beneficiaries insofar as if they get sued, the assets in the trust or foundation can't be accessed to settle that lawsuit because they don't belong to them. And likewise, if they get divorced, the assets in the trust or foundation aren't going to be available.
Absolutely, and that's a key thing as well, because obviously some wealthy families maybe are worried about the marriage partners of their children. Sounds a bit, I guess, perturbing for some people, but it's just the reality of the world, right? So that makes a lot of sense. Now, I presume then you are just on the tax side, right? So you do work in conjunction, presumably, with private bankers, different lawyers, companies like our own. But you yourself, of course, I guess you don't ever choose the assets unless it's from a pure tax point of view. You might give your opinions and say this is a PFIC or don't do this, but you don't actually manage the assets. You more manage the structure. Is that correct?
That's correct. So I'm focused on the tax and structuring side, right? So mainly I'm focused on designing the trusts and foundations, designing the holding structures, and then obviously advising on what the tax consequences are on those and trying to make whatever I set up for my client as tax efficient as possible. I don't give investment advice at all. A lot of times clients will come to me and say, hey, I'm thinking about making this investment. How does this going to be taxed, or how do I need to report this or whatever? And I'm happy to advise on that. But other than that, I don't give any sort of advice in terms of investments.
Sure. Now, you mentioned foundations as well as trusts. Now, what would you say are the key differences, and who should consider trusts and who should consider foundations?
So I think the easiest way to describe the difference between a trust and a foundation, I'll try to give a brief background. So a trust is actually not even a legal entity, as many people don't know this. A trust is essentially a contract between the settlor, the person who's setting it up, and the trustee, the person who's going to be managing or holding and managing the wealth for the benefit of the beneficiaries. What is a little bit what I don't like about trust, or makes trust a little bit complicated, is you need the actual trust agreement. You always need a third-party trustee. And so that means you either have to hire a professional trustee or you have to set up a private trust company. But you always need this third-party trustee. So it's always sort of a two-party thing, right? You have the trust, and then you have the trustee of the trust. And trusts can't even actually own anything in their own names. Everything has to be owned in the name of the trustee, because the trust is a contract. And trusts are a common law construct, right? So trusts are something that come out of the common law. In civil law, trusts don't exist. And so in civil law, there's this concept of a foundation. And the best way to think of a foundation is a corporation, but instead of shareholders, you have beneficiaries, right? And so to me, I much prefer foundations. In most circumstances, I'll prefer a foundation over a trust, because it's sort of an all-in-one entity, right? You have a founder that puts the assets into the foundation. You have a board of directors that manages the foundation, and you have the beneficiaries that benefit from the foundation. The one thing that trusts do offer as a benefit over foundations is privacy, because like a corporation, a foundation is an incorporated entity. So, obviously this isn't something that's registered with the government. You have to disclose, who the beneficiaries are, who the founder is, the board of directors. So there's certain information that is provided to the government. Whereas with a trust, at least here in the DIFC and in most jurisdictions, because it's a contract, it doesn't need to be registered. None of the people involved with it need to be disclosed anywhere. So it does offer additional privacy as opposed to a foundation. But I think most of the information that's provided to the government with respect to a foundation isn't public. And so to me, in most cases, I would still go with a foundation over a trust, even though it's a little less private, just because it's a lot easier to administer, in my opinion, and more cost effective. But if privacy is really a concern, then I think a trust is the way to go.
Yeah, so in the year 2000, when they were bringing out the EU Savings Tax Directive, which is automatic exchange of information on interest earned by anybody living in the EU and some other countries. Some other countries joined, like Switzerland. So I started consulting for the EU Commission, and it's quite easy to Google me, Mark Morris, economist, EU Commission, and you'll see me consulting. And you can see on my website a referral letter, a glowing letter from the EU Commission on my help to them. And I became such an expert that the Tax Justice Network started using me to write their papers. And then the Green Party in Germany called me to testify at the Bundestag about a tax agreement with Switzerland. I told them why it wouldn't work and that they should reject the tax agreement. And then I started consulting for the OECD. Pascal Saint-Amans was head of the automatic exchange. And then I did a lot of consulting for this residency by investment to avoid automatic exchange, and therefore they brought out a special paper on that. And there's quite a few articles on me in The Economist. You can go Google them. Of course, you got to subscribe to read the articles. So people ask, why did you consult for the other side if I'm advising on solutions that avoid all the automatic exchange? So it was to see what they could do and what they couldn't do. So obviously I'm on the inside, so that if I give a structure, it's permanent, okay, why they can't do it. But I'll explain later why I use the jurisdictions I do. Okay, so that's about me. Okay, so it's been, 25, 26 years of exclusively automatic exchange of information. I don't do anything else but exchange of information.
That's a really interesting point, because a lot of people in tax, they have like different specialties, right? Maybe 2 or 3, but you are just specialized in automatic exchange of information. But there are, of course, different forms of automatic exchange of information. So you've got the CRS, you've got FATCA, you've also got, I think it's pronounced CAF, right?
So the exchange, notice I don't say automatic exchange because there's also exchange on request. So we'll go over the origins of FATCA just on your next question, and that the EU Commission had the EU Savings Tax Directive, but they got rid of that when they adopted a version of the of FATCA called Common Reporting Standard, and then all the countries, 180 countries, signed the OECD Multilateral Competent Authority Agreement, which is 3 types of exchange of information. It's the automatic exchange of information, it's the exchange on demand, and it's the spontaneous exchange. So if a bank or a financial institution suspects something is fishy, they're supposed to spontaneously exchange that information, either with their government, if it's if it's a IGA1, or directly with the authorities, the other authorities. So FATCA is the one for U.S. persons, and that started in 2010. The rumblings of that started in 2008 and 9 when UBS and Credit Suisse, there was a whistleblower that he got incarcerated as well, but he got 100 million whistleblower reward. But he told the Americans how the Swiss banks were helping to hide money, how they would help the U.S. persons get the money. You know those stories about putting diamonds into toothpaste and visiting America, etc. So in 2010, there was a piece of legislation called the Higher Incentive Act, which was to help grow employment, but it was going to cost a lot of money. So, and then they said at the same time, a subpart of that legislation would be FATCA, which is so that we can start collecting taxes on U.S. persons with accounts overseas, and that would help pay for this new legislation to increase employment. And that's why it was on both sides of Congress, the Republicans and the Democrats. But the Democrats wanted it to be stricter, like, if we're going to exchange information, if we're going to get information, shouldn't we also give information? And the Republicans never wanted that because it would damage the banking, especially in Texas and Miami. So they never agreed to provide information equivalent to what they were receiving. The Democrats have tried since 2010 to pass legislation for the Americans to give the information, the equivalent, but the Republicans have always blocked it. And they've stopped trying since 2019, which is interesting. Maybe next time when the Democrats have all three parties, the House, the Congress, and the presidency, then maybe there'll be exchange of information coming from the states. But I wouldn't be holding my breath on that. So then the EU Commission and the OECD said, this is much better than what we've got. So let's adopt it, adopt FATCA. But of course, FATCA is aimed at US persons irrespective of their tax residence, whereas CRS is based purely on your tax residence. If you are a resident in one of the 130 countries that have joined CRS, then there'll be exchange of information. But there's still no information exchange on the other 70 or 80 countries that haven't joined CRS, like Serbia, Montenegro, Philippines, etc. And then when they did all of this, crypto was not a financial asset, funny enough. Okay, so in 2020, 21, they started saying we've got to have exchange of information for crypto, and it's called CARF, Crypto Reporting Framework. So crypto asset reporting framework. Notice they call it crypto asset. So the Americans haven't adopted that. I think they've got some internal reporting for crypto, but definitely not international. An American with crypto in another country, there's no reporting. But try find a crypto exchange to open an account for an American outside of America. It's pretty difficult, okay? So we'll get to the loopholes because there's one major loophole, which they've never closed, and we'll talk about what the Senate has said about closing that loophole. But when they did CARF, OECD saw this loophole, and they closed the loophole. I'll explain that later on. That's why they didn't close it for CRS, they closed it for CARF, and therefore if you want a structure that avoids CARF, it must be a different structure to the one that avoids CRS.
That's very interesting. So the tax authorities knew that there was this loophole in the CRS, so they closed it for new agreements like the CARF.
Yeah.
So what would you say are the major loopholes that exist in some of these tax agreements like the CRS and CARF?
There are some exemptions, like some broad-based retirement plans and giving the money to the lawyer to keep for you and so on. The OECD used to bring out what is called still the OECD CRS frequently asked questions. And they brought that out 2017, 18, and 19 every year. And they would highlight the new sections in yellow, which was closing the loopholes. They went after loopholes in Singapore with trust. They went after loopholes in Hong Kong with pension plan, also as it's called, pension plans. But then they realized closing loopholes this way with new frequently asked questions was like trying to stamp out cockroaches in the kitchen. There's always going to be more. So then they brought out what is called the mandatory disclosure rule. So anybody promoting or anybody forming or designing a structure that avoids CRS or is opaque and therefore hides the beneficial owners or controlling persons, you're supposed to report that even if you hear about it, you're supposed to report that to the tax authorities, and then, okay, nothing's ever been closed on that. There's been hundreds of reports, but they've never done anything on that. But why that was a complete flop, the EU adopted it, and only 10 countries outside the EU, South Africa, etc., adopted it. The rest, like Switzerland and Liechtenstein, said, we've got too much on our plate. We're not going to adopt a whole new legislation. So, and so what is that? 90 countries, maybe even more, just didn't adopt it. And then another reason why that's a complete flop is it actually exempts any promoter or lawyer or supplier that lives in is resident in a country that hasn't adopted mandatory disclosure rules, such as Switzerland. If I'm doing all these designings and promoting from Switzerland, there's no MDR, mandatory disclosure rules. And I think the biggest weakness that they had was lawyers throughout the world are excluded from this for confidentiality reasons, the privilege of confidentiality and so on. So lawyers can talk about structures, and they are not part of the mandatory disclosure rules. So that's a complete flop. But now, I've told you about minor loopholes and so on. It can be more complicated, like one trust settling a second trust, and therefore the settler of the first trust is a trustee. Okay, I'm not getting into complex things, but the simplest and most well-known loophole of exchange of information, which is easy to check on AI. Okay, go to DeepSeek and say, what is the major loopholes of FATCA or Ceres or this one? It's called the shell bank loophole. So the Senate Finance Committee in the U.S. wrote a 40-page report on this particular loophole. Why? Because there was a billionaire, multi-billionaire in the U.S. His name was William Brockman. He was a private equity investor. He worked with Bernie Madoff. Okay. So he was the biggest single case in U.S. history on the individual avoiding tax. 2.7 billion tax he avoided. So using the shell bank loophole. The shell bank, funny enough, it doesn't mention it, but it describes it. So I'll describe it in language everybody understands. People set up an investment entity, which is a company that earns financial, more than 50% of its income is financial, passive income, and more than 50% of its assets have the potential to earn passive income. So even if you're holding cash with no interest, it's still got the ability or potential to produce interest. Therefore, it's part of being an investment entity. And then if you appoint a professionally managed asset manager, doesn't have to be an FI, but professionally managed, then that entity is a financial institution. And any bank or financial institution that has an investment entity as its account holder, so the bank account holder is an investment entity. The weakness of FATCA and CRS is one financial institution doesn't report on another financial institution. So why did they have that weird weakness? It's because they didn't want duplicate reporting. They didn't want one financial institution reporting, looking through that. And so the weakness is this investment entity or shell bank gets a GIN, Global Intermediary Identification Number, ticks that it's a financial institution, an investment entity, and then the bank doesn't look at that at all, doesn't report, doesn't do anything. Now, the investment entity as a financial institution has obligations to report on its account holder, which is usually the person that set it up. But he just keeps his head down and illegally reports, files. There are no reportable persons. And the weakness is there's no or very little auditing of these investment entities. So what the U.S. in this 40-page report is that if an investment entity files that there are no reportable persons, then there should be an audit. So that would be part of FATCA. So maybe the authorities in the country that you set up, and most of these they say are set up in the BVI. They said like there's 160,000 investment entities there, but the population is like 30,000. But investment entities can be in any country, okay? But they mostly go for, it's not BVI, it's Cayman Islands, funny enough. So there was an anti-abuse shell bank legislation written by the Democrats in 2022 to say that if an investment entity files that there's no reportable persons, then there should be an audit saying, okay, if you're saying that there's no reportable person, who are the reportable persons? And if it's a US person, why did you not file? And then you get all the penalties. Okay, so I think that loophole has a limited life. When you talk about loopholes, that's I mean, there's 40-page report from the Senate. There's this new legislation that's been around for a few years, never been passed. But I know from clients that they say, I'll just do an investment entity and not report to myself. But that has a limited life. And if you get caught, the penalties are going to be horrendous. 50%, 100% of your assets and so on.
So, Mark, how about CARF then? How does that differ from what you just spoke about?
The CARF was written mostly by the OECD, not by the Americans, because they don't have CARF. They've got their own internal reporting for crypto. So CARF went after the shell bank loophole, and it's only in one sentence. Even I had missed that. My lawyer pointed that out to me. There's one sentence in all of CARF, and CARF is about, 40, 50 pages, and there's one sentence, and basically it says, if you're an investment entity, financial institution, the crypto asset reporting institution, like the exchange, must look through investment entities, look through to the controlling persons, and report on anybody who owns more than 25%, etc. So what CARF has done is just ignore that investment entities are non-reportable financial institutions. They are still financial institutions, and they've still got their own reporting obligations. So there's duplicate reporting, one by the exchange, etc., and also obligation on the investment entity to report on itself, which is interesting because the whole reason that they left out one financial institution reporting on another, they didn't want duplicate reporting. And here, all of a sudden, they don't mind duplicate reporting on CARF for investment entities. I mean, what other financial institution are people going to use? There are 4 types of financial institutions in automatic exchange. There's depository institutions, which is banks. So unless you set up your own bank, you're not going to be a financial institution. There's investment entities, which everybody uses. There's specified insurance companies that set up PPLIs and other types of annuities that are cash related, cash value related. And then the last one is the one that hardly anybody understands, is the SPV custodial institution. SPV means it's a custodial institution for you and you only. It doesn't mean it's Pershing Bank or JP Morgan, although they are financial. But the one that people could use but don't understand is the SPV custodial institution, which is mentioned, funny enough, in the OECD frequently asked questions about can payment for fees to SPV custodial institutions be paid to third parties that do the administration? And they said yes. So you don't have to actually pay the custodial institution. You can pay a lawyer or accountant.
Okay. So that's interesting. So these custodial institutions, SPV custodial institutions, you say they're quite different to a lot of the other structures and a lot of people don't understand them. So why might somebody want to use that structure, for example?
Okay, so now we're getting into the only solution that I think it works and will work forever, okay? So I told you the basis is that if you've got a chain of financial institutions, one owning the other, one owning, then nobody reports except for the top level financial institution. And I always ensure that the top level financial institution is a custodian, a SPV custodian institution. That means it's your custodian institution. Now, normally you would have to report, because this is interesting. For CRS, they said that if you're an investment entity located in a non-participating jurisdiction, let's just say a Serbian company, or, there's still 80, 90 countries, then the underlying financial institution must treat that like a passive NFE and look through to the controlling persons. And if there are other financial institutions in the chain of ownership of that investment entity, they must carry on looking until they finally find the controlling person. Doesn't matter if those other financial institutions are non-reportable. So using a investment entity in a non-participating jurisdiction is an absolute killer, and a lot of people don't know that, okay? But there's no look-through of a custodian institution, because normally a custodian institution is JP Morgan. What are they going to look through? Jamie Dimon, or somebody who owns 5% or 15% of a custodian institution? There's no, but nobody, and I tell you now, nobody, so for me, uses SPV custodian institutions. That means you can look at what the SPV structure is. It's separate from everybody else. It's for the risk of you. But if in effect it's your custodian institution. So what is a custodian institution for CRS and FATCA? Because they copied each other, and it's in COF, exact words. It's an entity, and entity in automatic exchange is a company, a trust, a partnership, a foundation. It's basically, it's anything that's not skin and bones, or like somebody trading, okay, that holds assets for the account of somebody else, so not for its own account, and earns more than 20% of its income from custody fees. So the type of entity that I use is a trust. So the trust is a custodian institution. Why? Because if a trust owns a company, an investment entity in my case, then it's holding that company shares for the settler. So it's holding the shares of the underlying company for the settler. It's not holding the assets of the underlying company. So the structure is quite simple. It's two levels. It's the SPV trust, custodian institution trust, which holds an investment entity company. And the investment entity company holds stocks, ETFs. It can even hold some operating companies, as long as the total financial assets and assets that produce passive income is more than 50%. So I often have banks who don't understand this, and somebody says, I've set up a consulting company, or, and I've got lots of cash, or I'm investing the money. Is that an investment entity? And they say yes. And it's not, because the income must be passive income, more than 50%. And passive income is dividends, capital gains. It's not consulting income. But so many banks say you've got cash, or they say, what are you holding the cash for? And they can say, well, I'm holding it to invest. Or it gets worse. They say, I'm holding the assets to buy widgets for a company, or to buy an operating company. Then the bank says, well, then you are active NFE, and that's non-reportable completely. So there's so much misunderstanding with CRS. It's ridiculous. Okay. So the structure that I have is simple. It's an SPV custodian institution, which is a trust, and it owns an investment entity. The bank doesn't report on the investment entity because it's a financial institution. The investment entity files once a year. We have no reportable persons. This wasn't like Bill Brockman filing, I have no reportable persons. He owned it. He should have reported on himself, but he just lied. And somebody who wanted to earn the 30% whistleblower fee blew on him, 2.8 billion. That's a big whistleblower reward, 30%. And he got he got found guilty, and he was going to be incarcerated. He was 80. and he fell over on the golf course, and that was the end of that case. Yeah.
I heard of that case, but as you said, that case was the so-called US shell bank loophole, right?
Yes.
But what you're talking about is quite different. Now, what's interesting is when people think about trusts and other structures, they often think about jurisdictions, right? They think about, well, is it good to go in, I don't know, Guernsey, Jersey, Singapore, or this jurisdiction, Cayman,
Cook
whatever.
Islands is popular.
Cook Islands. So are you jurisdiction agnostic, or do you have like some favorite jurisdictions you like to use?
There's only one jurisdiction in the whole world that I see you using. Now, be careful when you use the word jurisdiction. You are talking of the governing law or the proper law. It doesn't mean that the trust is there. It just means it's the law. Just because. So the UK has three types of trusts category. They have the normal UK trust. So that's with UK trustees or UK settlers. That's 95% of trusts. Then they have non-UK trusts, which is a UK person using a Jersey trust or an Isle of Man trust. That's called non-UK trust. But the settler is still UK, but the trustee is not UK. Okay. But the third one is the one that's least understood, least used, least spoken about. Try and find information on this, but it's there. Under HMRC, it's easy to find information. It's called the UK non-resident trust. What does that mean? Okay, so it's a UK governing law trust, but none of the trustees are UK resident. And before until February this year, none of the settlers should be UK resident. But they changed that in the UK. Up until February, they said if you deal with a UK relevant person, there are 15 types of relevant person: notaries, high level gold traders, or property agents, etc. Then you must register on the TRS. But in February this year, they changed it all. It's quite simple to be non-resident. If you are not UK resident and none of the trustees are UK resident, then you are non-resident trust. I'll look into more what happens if you are UK resident and you're going to change, okay? Because then you can use a non-resident trust, okay? But so what's the advantage? Why do I say the UK is the be-all and end-all of trust? UK non-resident trusts have a couple of unique features that are not available anywhere else in the world. So the trustee is resident somewhere else, which means they are not registered on the TRS, the Trust Register Service, which is the beneficial owner register. A lot of other countries like Guernsey or Isle of Man say, well, we don't register that in the central register, but it is registered with the trustee and the information is available. Here, this trust is not registered at all with TRS. That document that you sign and we get a apostille is private between you and the trustee. It's not registered anywhere. And if the trust doesn't have income liability, and of course, outside of the US, it's difficult for a trust to own anything because it's just an arrangement. Whereas in the US, trusts can actually own assets, but not in not outside the UK, US. So if the trust is not liable for any of the 6 types of UK taxes, income tax, capital gains tax, tax on shares, tax on property, etc., then the trust is not registered with HMRC either. So it's not registered with HMRC, it's not registered with TRA, it's not registered anywhere. And so that is much more confidential than, say, Cook Islands, because Cook Islands has common reporting standard, and they must report your trust and all trustee details and benefit back to your country. And even though they've got their own laws about, well, try to get hold of the assets, it's difficult, you've got 2 years, you must you must claim here, etc. The fact that the information is still transparent, okay. There were some big cases, especially Bernie Madoff and so on. People put their assets into Cook Island Trust. Now, a lot of Cook Island Trusts are crazy popular because people don't understand. So the courts were finding tracing assets for people who put money into Cook Island Trust. The court said, okay, we can't get the assets, but if you don't bring back the assets within 6 months, we're going to sue you or put you in jail or take your other assets. So much for the Cook Islands. Okay, whereas I use a jurisdiction where it can't be found out. Okay, we'll talk about Norway. Yeah.
Sure. So you mentioned about these non-resident UK trusts, and they can have, or they should have, a trustee which is by definition not a British trustee. So you use Norway typically, or a jurisdiction or a place in Norway, right? So tell us more about that structure and why you think that works.
Okay. Norway has 5 dependencies, 3 in the Antarctic and nobody lives there, 1 near Greenland where there's only like 80 people, 40 military and 40 weather people. Okay, it used to be Dutch, called Jan Mayen. And then the one that's critical to me is Svalbard. Svalbard means cold coast, okay? So Svalbard belonged to nobody up until the 1920s. And there was a lot of coal mining there because the best coal in the world, and they would sell the coal to German Krupps, etc. Because it used to be an island on the equator in the Atlantic and then floated up over millions of years. So in 1920, the different coal mines there were Russian, there were Norwegian, Finnish, Iceland, even the Dutch had coal mines there. And with no law, didn't belong to anybody. It was the Wild West. And they would be fighting over the land claims and so on. So they knew they had to come under the sovereignty of somebody. And everybody wanted it. Nice piece of land and fishing and so on. But the only one they could all agree on was Norway, not because it's closest to Norway. It's still 800 kilometers away from Norway. In fact, it's closer to the North Pole than it is to Norway. Norway was the only country that had goodwill because it wasn't partaking in the First World War. And so they got 48 countries to sign the Treaty of Svalbard, 1925. Svalbard before this was known as Spitsbergen, and some double tax treaties like America still call it Spitsbergen, but it's Svalbard. Funny enough, the biggest island in the Svalbard has many islands. It's double the size of Belgium. It's got, it's a big island, but people don't see it because when they were kids, and there was a globe in the classroom, the nut at the top of the globe would cover Svalbard. So they never saw it as a kid. But people have seen the seed vault that's there. The seeds of the world are kept there. And the Treaty of Svalbard has got 8 clauses. Not long. The whole treaty is maybe 5 or 6 pages. But so the Treaty of Svalbard gives autonomous areas like fishing, like coal mining, like environment. Immigration is important, and I explained that just now. But the one that's important for me is the tax aspect. It's tax autonomous. So it's an integral part of Norway, but it's tax autonomous. And the treaty says that any of the signatories, there's 48 of them, that they must all be treated the same. There can't be any benefit given from one to the other, and that any tax that's collected must be only for Svalbard. So therefore, when Norway does a tax treaty, and Norway's got a lot of tax treaties, over 100, they always say in page 2, the definition of Norway is, continents, but excludes Svalbard. It also excludes the other dependencies, but that's irrelevant. So the U.S. tax treaty, it's between Spitzberg in the US, Canada as well. But every treaty in the world, just go randomly look at Mexico, Japan, anything that's got tax treaties. It will say the same wording, same paragraph. The definition of Norway excludes Svalbard. So whenever they do any type of tax treaty, including the OECD Multilateral Competent Authority Agreement, which is the one that's the legal basis for exchanging information, it's got the same paragraph. But Article 29 of the OECD Multilateral Competent Authority says any country can include or exclude a territory from this multilateral competent authority. And the only one in the whole world to utilize that article is Norway. Okay, so only Norway excludes some of its territory. So this is vital for everything. If a country doesn't have a tax treaty, it can never join something like CRS. It can, but more importantly, and I told you exchange on demand is more important than exchange, automatic exchange. No country can ask information to Norway about an entity in Svalbard. Who owns this? What's the tax situation? So our trust is there, so nobody can ask a question about the trust. But more importantly, the underlying company owned by the trust. We're going to why use British companies, but I suppose you could use some others. If you've got a British company as the underlying investment entity, UK law says in Company House, when you register the person of significant control, they use the word person of significant control in lieu of beneficial owner, okay? It's their own rules. It's not the FATF rules. So the own rules of Britain, of UK, of a company owned by a trust is the trustee. It's not the settler. It's not the beneficiary. It's not the protector. It's nobody, just the trustee. Unless the beneficiary can change things in the trust, which I've yet to see one like that, okay? So therefore, if there's any query on the tax situation or financial situation of the investment entity, like they said they would do audits in the future, they can't ask a question, who's behind this company besides the trustee? And they can't ask the trustee any question because the trustee is in Svalbard. So it's far better than using Cook Islands or Jersey or Nevis, because that information is going to come back. Here, they can't ask. There's a famous case, Jimenez, where some British guy ran to Dubai and was hiding assets using his Dubai company. And HMRC asked him questions about his tax situation. He said, I'm outside the UK, I'm not answering you. So there was a court case that went up all the way to the High Court, and it said that the HMRC can ask these questions that are outside, where the taxpayer is living outside the UK. And then they said, but if he doesn't answer, like he didn't answer, then you can use the tax treaty to force the exchange of information. And I think UK and Dubai, so the UK authorities would force him. And then it also said, if you're still unhappy with the result, you can penalize him using the assets in the UK. Well, I don't keep any assets. I don't use a UK bank. Okay, so the structure is, when you say Norway, it's Svalbard, but Svalbard's part of Norway, holding a UK company, because the person of significant control is the Svalbard trustee. So nobody can ask any questions on tax or finance to the owner of the person of significant control, and nobody can ask about the trust because it's a trustee in Svalbard, and there's nobody even there to answer questions. They've got Department of Fisheries, Department of Dog Sledding, there's no tax, International Tax Department there. So the question is, will this change? So there's two questions here that you can ask. Will the UK ever change its law on non-resident trusts? And non-resident trusts have been around since the Crusaders, because it was the French. You know how the Crusaders work. Some Crusader would give his, it's a story, they don't know if it's true, but it sounds good. Crusader would give his farm to somebody, and they would be the trustee to the. And then when they came back, they said, "Can I have my farm back?" And the guy would say, "Get lost! It's my farm." So they came back with trust law. They'd say, "You're the legal owner, but not the beneficial owner." So I don't see the UK changing that law, non-resident trusts, and there's hardly anything written about it. Not going to change it because of me. And then the other question is Svalbard. So Svalbard has got 48 countries that signed the Treaty of Svalbard, which is the one where there's all the tax autonomy. But there's other things that are in that treaty, like if you are a resident, a national of one of the 48 countries, you can go and live and work in Svalbard without residence, without a visa. But anybody in the whole world can go visit Svalbard, without a visa. You just got to fly to Norway, and then you stamp out of the Schengen. And then when you get there, there's just a warehouse. Your luggage is sitting in the warehouse, and you go pick it up. There's nobody to greet you. No customs, no immigration, no nothing. Okay. So now on the due diligence documents that the banks ask, the address that we give for the trustee is as follows: They, which means road, 228 is building. The buildings there are numbered, and you can Google the building. They 228,9.9, but it means apartment number 9 or office number 9, comma, Longyearbyen is there's 2 villages or cities on Longyearbyen, on Svalbard. The biggest one with a population of 2,000 is Longyear. Longyear was an American who arrived there on his private yacht in 1906. And they all ran down to him and said, "You should set up some coal mines here. The coal is big." And he did. And then when they signed the treaty, he sold those mines for a fortune to the Norwegian government. So the government owns the mines. And then there's a Russian town there, 400 Russians, 400 Ukrainians, but most of the Russians have left because to get there, you could fly or take a boat from Murmansk. Now that's cut off. So they must fly via Norway, and quite difficult to do that. And that is called, I forgot the name, the Russian town, okay? But the Russian town is under the sovereignty of Norway, okay? So the address is Vey 228,9, comma, then the postal code is Norwegian because it's part of Norway, N9170. Then comma Norway. I don't say comma long. I say comma Longyearbyen, comma Norway. I don't say Svalbard because it's part of Norway. And then the banks see a Norwegian trustee on the UK trust, and they see a underlying company. I'll tell you the truth though. 90% of my clients, or 80%, are Chinese because I've got a very good Chinese broker. And none of them use a UK company. They use Hong Kong and everything else, okay? But I like the UK company because of they don't seem to be scared of exchange on demand. You know, they use Seychelles, they use Belize, they use Marshall Islands, they use Singapore, okay? But for me, if you truly want confidentiality, and we'll get to the PEPs you spoke about just now, then use a UK company. And simply declare your company as dormant. Or you can set up a PPLI underlying, and then that company has no assets or income. So there are three ways of getting your money out of the structure. One is you set up a PPLI, and the PPLI owner, the policy owner, is the company. And so the insurance is not going to report because the owner is an investment entity, an FI. And so you can loan up to 85% of your assets and you're loaning the money from the insurance company you're borrowing, not from your PPLI. So, and people, insurance companies loan money. That's a major activity of theirs. Now, you set up the interest rate. You say, I'll pay 7% because it's supposed to be uncollateralized. And then the insurance company will take 0.5% or 0.25%. And the rest is surreptitiously added back to your policy. So now if you're using the loan for business purposes, then the interest is tax deductible where you live. So you can deduct the tax, but it gets put back to your policy and you can borrow it. And so no country in the world, I've looked this up, every country, even the States, if you borrow money and you never pay it back, there's no, after 5 years that becomes taxable income. Somebody told me that in Switzerland and I broke my back to pay back in 5 years. I didn't have to. The accountant didn't understand. It cost me a lot of money to pay back. There's no conversion of that loan into taxable income. No country in the world says you haven't paid back, we're going to regard that as taxable income. However, if the party that you borrowed the money writes it off and says you don't have to pay us back, then that's taxable income or taxable capital gains or whatever. Okay. The other way, which is common, is the banks, most of them, will issue you credit cards. So I got a Swiss bank. He gave a guy from Korea. He gave them 3 credit cards, a debit card. No, he gave them and 3 currencies. Now I remember. One set was a debit card, one was a credit card, and then there were 3 currencies: sterling, dollar, and Swiss francs. You could have got a euro one as well. And those you can have 50,000 on those. So you work there, that's 8 times 50,000 per month. Okay. So that's a way of getting. Now, a third way of getting your money is there are companies, finance companies, if you give them collateral, they're not related to you, then they'll loan you the money. But there, the 7 or 8% they charge you is money lost forever. They'll keep it. And entities. And I was talking about your assets are held in an investment entity, and CAF would look through investment entities. So you couldn't use the same company. You can use the same trust, but not the same company. The company you must use must be, listen carefully, must be a non-financial institution. So you can't have somebody managing the money. And it must be it must be a passive entity. So the company that's holding your crypto must be a nominee. It must say, we are holding the assets for somebody else. Who's that somebody else? It's owned by the trust who's holding the assets for the settler. Therefore, you tell the bank, this entity, which is not a financial institution, is a nominee for the trust or for the settler. So CRS, FATCA, and CAF says, if an entity is not a financial institution and is holding assets for somebody else, it's a nominee. And they use other words, straw man and signatory and agent. But if you're one of those and we're a nominee, then you're not regarded as the account holder. So this entity is not regarded as the account holder. Who's the account holder? The account holder is the party you're holding the assets for. And we're holding the assets for its owner, which is the SPV custodian institution. And therefore, when it's time to report, if the owner is deemed or regarded as the custodian institution, because it's an FI, that's not looked through. There's no reporting on FATCA. Sorry, on crypto.
Fantastic, Mark. And what about for politically exposed people then who just want confidentiality? What would you say in that case?
Okay, so for us, we don't care about PEPs, okay? I mean, PEPs, they say, must have added due diligence. your issue is the bank that would accept, and banks accept PEPs. People think they don't. Okay, they do enhanced due diligence. Is this money that he's got because he's in a PEP situation? Banks, you ask any bank, they'll tell you that they accept PEPs. But I can give you banks that are only too happy to take PEPs. I think they're based in Nevis. Their headquarters is in Luxembourg. So I can help, or you shouldn't be too scared, but I think it might take a bit long if you just go to a random bank and say, can this PEP? Now, the PEP doesn't, the only person who knows it's the PEP is the bank. The UK company has the trustee in Norway, in Svalbard. The trust has only the trustee. The PEP's not mentioned anywhere. So, and nobody can ask the trust or the underlying company questions about the company, about the PEP, about the source. It's down to the bank. And if the bank's happy to have a bank account in the name of the company, but knowing that it's the final beneficial owner is the PEP, it'll work. And it can. I mean, I'm working with some very well-known PEPs. Okay, presidents of companies and presidents of countries and their brother, billionaires. But billionaires before they were even voted, like Indonesia, etc.
Also, Mark, what changes do you see happening potentially in the next few years? So, for example, what about real estate? Do you think real estate is going to be included in some of these exchange on demand and other agreements?
Yes. So the first change that I see happening is if you're using an investment entity, a shell bank, that is not owned by another financial institution, I believe within 5 years, maybe even less, there'll be audits that are required to say, the bank will ask, you reported, it's easy. The bank can see, you reported, or the country, you reported no for FATCA, you reported no for CRS, you're an investment entity, shell bank, what the hell's going on? Who's this magic person that you, it's so easy. It's so stupid to use that loophole. Because you can't keep for FATCA and CRS report no reportable persons. Okay? So, second of all, you can AI or Google this. India was really pushing the OECD to include real estate because I think the Indians, maybe even China as well, are sending money out. And people in China send money out via the Belt and Road project, which never happens. Again, then they buy property and it's not reported back. So it's very interesting that one of the effects of FATCA is that the Americans invested a lot of. So what money did they invest in? Property and gold and paintings, art. Okay, so property is coming for sure. You can Google it, and the OECD is talking about, I think they said as little as 2 years from now, that property will be included. I'm working with a real billionaire. He sold his AI, lucky him, Spanish guy. I said to him, if you want the ultimate secrecy, confidentiality, then have our trust, because it's a trust, our custodian institution, settle a new trust anywhere in the world with any trustee in the world. The settler of that new trust is the trustee, at least in UK, in non-US terms. It's not the trust, it's not the original, it's the trustee, because the trustee owns the assets. I'm giving you this company. And the new company, let's say in Malta or Cyprus or Singapore, the trustees would have reporting obligations, but they're not going to report on the settler because the settler is resident in Svalbard and somebody in Svalbard is not reportable because they're not part of CRS. So talk about ultimate secrecy. Of course, if you're PEP, try find another trustee that would take you, but could be.
That's a different matter.
Now, when it comes to trusts, of course, most people setting up trusts is more for wealth preservation as opposed to just growing your wealth. Because if you just want to grow your wealth in isolation, you don't need a trust to do that, right? So it's more about protection. Now, what are the biggest reasons, would you say, why people come to you for trusts? Because most of your clients, it seems, are actually, if I'm not mistaken, outside of Singapore or foreigners in Singapore. And local Singaporeans are a minority of your clients. But for both cases, why do you think people set up trusts? There must be like 2 or 3 key reasons why they do that, right?
So I think, of course, the number one reason which the number one reason why people who want to set up a trust definitely is due to preservation. They do not want their assets or their wealth to disintegrate over time. And this is true, this is true across all cultures, right? In the Chinese, they have this saying called "fu bu guo san dai," means your wealth doesn't last 3 generations.
Yes.
And of course, in the US, you have big families like the Vanderbilts, who are very, very wealthy, but without proper administration and overspending, they're basically non-existent now, right? So I think a trust is the best instrument to preserve your wealth, and it's also the best instrument to protect your wealth. Most of the clients would want to set up a trust, not just for preservation, but to protect the wealth against possible creditors and sometimes against family members also. Now, that's something that's quite controversial to say sometimes, but it's actually something that's very normal nowadays because a lot of people are just worried that their child marries someone that might not have the best interest at heart. So a trust actually helps to protect their assets from going into the hands of the wrong people. Yeah.
Absolutely. And it's funny because before we go on to that issue, what you said about the Vanderbilts is very true, because if you compare the Rockefellers to the Vanderbilts, apparently one of the things the Rockefellers did was they set up what was called the Rockefeller Waterfall method, where they had a trust and they got life insurance against the trust and they built this whole system. Whereas the Vanderbilts actually didn't do that. And that's often used as like a comparison between like 2 different methods. But what you were just saying is fascinating, because I think obviously in the world we live in today, where people can be a bit sensitive all around the world, they want to sometimes sound politically correct. I guess in reality, most people don't come to people like you and I and say, well, look, the reason I want to set up a trust is that I'm worried about my daughter or son, marrying someone who's a gold digger, right? Most people don't just say it openly in the first conversation. But as you say, there are a lot of emotional reasons why people set up trusts. Ditto litigation. Most people won't just come out with the statement that, oh, I want to set up a trust because I'm worried in 5 or 10 years I'm going to get sued. But in reality, that's a big factor for some people. But as you say, probably the family dynamic is a bigger one. And what's also interesting is, if I'm not mistaken, Singapore and also numerous countries for that matter do not recognize prenuptial agreements. So I think for some people, it negates that need, right? If you actually have the trust looking after the assets, right?
Yep. First thing first, I'd like to just clarify that I'm not a lawyer, but what I understand is that prenuptial agreements and postnuptial agreements in Singapore are not recognized, but are used as a guideline when it comes to divorce. So if it makes sense to the judge, they might follow. If it doesn't make sense to the judge, they might throw it out. Or they might just take certain parts of it as a guideline. So, but you're absolutely right that the most efficient way to protect your assets against a divorce is putting in a trust. Yep. So I think that's something that a lot of my expatriate clients would know. They thought that, by having a prenuptial agreement, that would be the be all and end all, and that's it. But it doesn't work like that in Singapore, because in Singapore, the woman's charter is pretty strong. And there's a lot of factors that comes into play when there's a divorce, like is there children involved, is the lifestyle of the spouse, has it, dramatically improved when she got married to you. So all these are taken into consideration in a divorce, right? But what I understand, again, that prenuptials are not recognized. So definitely by getting a trust, it's a foolproof way of protecting your assets.
Yeah. And as you say as well, talking about difficult conversations, in some ways it's easier to set up structures than to have these difficult conversations, because let's say your daughter or your son is marrying someone who you are not particularly keen on, let's just say. It's a very awkward conversation to say, well, let's get that person to sign a prenuptial agreement. And that person might think, hold on a minute, you don't trust me? Why are you getting me to sign this document? Whereas if the assets are already in a trust, you probably don't need to have that conversation. Obviously, it's always an individual decision. Some people might want to do both things, right? But it does avoid those difficult conversations as well. Because I think a lot of people out there don't want to have those conversations for obvious reasons.
You're absolutely right.
And I think another factor as well is, if you think about it, most high net wealth individuals and expats have assets and companies and properties all around the world, or at least in 2 or 3 different locations. And if that's the case, for some people, I guess they want to actually have like a holding company and a trust, because at least then there's like a centralized place to manage them. And it makes things like estate planning easier as well, right? Because not just estate planning, but let's say, God forbid, you were to become disabled or incapacitated. If you've got one holding company and trust that can manage all the assets, it makes it simpler, doesn't it?
Yes. So basically, in Singapore, how the trust system works is that you have a holding company. You got to set up a holding company, and that is the entity that holds your assets, right? If you intend to invest, then you might come up with a different corresponding company, a VCC, but it's a little bit more complicated. But end of the day, on top of this, you have a trustee. The trustee, you have the trust and the trustee. The trustee is the company or the corporation that administers the trust. The trust is not an entity. The trust is an agreement. Yep. So the trustee's duty is to follow whatever in the trust deed and the letter of wishes according to what the settlor wants. The holding company is just the instrument that holds all the assets.
Absolutely. Now, what are the biggest fears, would you say, for your new clients? Because ultimately, a trust, you are giving away assets on purposely, because you don't want to own them directly yourself. So I guess in reality, control might be near the top, but are there any other worries people have? And when it comes to control, are there still certain ways people can retain as much control as possible?
For how it works in Singapore is that you can start out the trust as a revocable trust first, and eventually convert it to an irrevocable trust. But you can't do it the other way around. Okay? And once things are irrevocable, of course, you can't change it. But in Singapore, there's a few, there are few methods of control that you can have. Number one is that the trustee's job is just to administer the agreement in the trust deed. The trustee's job is not to take your money and invest it. A trustee doesn't do that. So once you have set up a trust, you have to appoint an investment manager. So let's say you set up a trust. You are the settlor. You can also be the investment manager. So you will take charge of investing the money wherever and however you want it. But of course, in accordance to the trust deed. So what you can put in the trust deed is like, okay, if the investment manager should be making at least 5% year to date over 3 years, for example, right? And of course, if that's your job, you have to fulfill that. And if you don't fulfill that, the trustee might take away your responsibility for that and get the settlor to choose someone else. So of course, the ironic thing is that if you are the settlor and the investment manager, then there'll be a bit of a conflict, right? So usually, sometimes the investment manager might not be the settlor also. But as the settlor, as the investment manager, it is at your own prerogative how you want to change certain things, how you want to invest the money. So, do you still have control over your money? You still do. Mm-hmm. So you don't have to worry about that. And on top of that, you have something called the trust protector. What a trust protector's responsibility is that if the trust protector is not happy with the trustee, they can change the trustee. The trust protector is not the settlor. It's someone else. It can be the son. It can be one of the beneficiaries. Yeah. Mm-hmm. So there are still some provisions that that the family has when it comes to setting up a trust. But of course, most of it is still kind of set in stone.
Sure.
Yep. Mm-hmm.
And that also means that people can keep the same relationship. So let's say, for example, you've got someone who's a relatively wealthy individual. They've got their private banker or their wealth manager. Of course, they can change their accounts usually to a trust account. So say, for example, if one of my clients decided, you know what, I want to set up a trust in Jersey or Guernsey or Singapore, then it is possible to keep the relationship with me and then set up a trust, because the trust's only job is to follow the actual deed, right?
Yes.
So therefore, it is possible to keep the basic structure the same in terms of your investments. But as you say, if somebody prefers to do it yourself, DIY invest, they can put certain rules in the trust, right? Like saying, okay, 90% is invested into stocks, and these are the criteria, 10% in government bonds. So they can do that, right? But obviously, when it comes to things like distribution or things like that, also certain rules, they do need to set that in stone, don't they? But I think you can change the trust deed, right, if you want. That can be updated, can't it?
Yes, so you can update the trust deed, definitely, because the trust deed is a legal document. So yes, going back to what you said about keeping the relationship, or rather the structure, the same, and I think that's really important, because as a high net worth individual, you have taken years to build up your structure that works well for you. So even when you are setting up a trust, you're just putting an extra layer of protection without losing the structure. So I think that's really important. Your investment manager can still be your banker, or you can get an external asset manager to overlook all the bankers. So it just really depends how you want it. And going back to the trust deed, so when you set up a trust, there's actually two documents that you have to fill up. One is the trust deed, one is the letter of wishes. Now, the trust deed is legally enforceable, but the letter of wishes is not. But the letter of wishes will be a little bit more detailed, whereas the trust deed is a little bit more generic. Yep. So, for example, let's say for the trust deed, you can put who are your beneficiaries. Let's say you have 4 beneficiaries. You can just list down their names there. Now, and the letter of wishes, that's where you put what they will each get. Yeah. So, in this way, it protects them, because with your trust deed, because it is not stipulated how much they are getting, because it's a legal document, whatever assets that will go to them is not considered matrimonial assets. Whereas if you were to put, let's say, you have a son and a daughter, you put 50, my son will get 50%, my daughter will get 50% in the trust deed, and one day they get divorced, that 50% of your son will be considered as matrimonial assets. Whereas if you put it in a letter of wishes, we will not be considered matrimonial assets. So I think that's another layer of protection that we actually advise clients to do.
Sure. And I think another factor here as well is some people think to themselves, well, if I've got assets in different countries, I should have wills in different countries, or I could invest in an insurance provider because I can list beneficiaries. But I think one of the key things about a trust is it gives you the ability as well to make certain rules, like, for example, if you become disabled or incapacitated. And also a trust can own pretty much any asset, right? In terms of it can own property, it can own stocks, it can own companies in numerous countries because it's like a holding company. Whereas, of course, a will is just if you die, right? So in a way, a trust can act like a living will as well, for lack of a better term. And obviously, when it comes to insurance companies, they're fantastic for just like maybe stocks and bonds and assets and then moving them quickly to the beneficiaries if you die. But they can't hold, say, properties or businesses. So really, it's a way of saying, well, if something happens in my life as well, like disability or whatever, I can be covered as well.
This goes back to what I said right in the beginning, that as my job as an estate planner is actually to understand your situation and to provide you the tools and instruments that will help to fulfill the strategies that we agree on. So a will is part of the strategy. A will is part of a will is an instrument. A trust is an instrument, and life insurance is also another instrument. It doesn't mean that if you use a trust, you don't need a will. It doesn't mean if you have a will, you don't need insurance, and vice versa, and all that. It all can be used in tandem. Yeah, because we want to specifically, structure things in a way to move things differently. Maybe an example will be like, let's say we talk about Singaporean couple, they have a private property in joint name, right? And let's say the husband starts a trust. So he can't put the property into the trust because he will need the wife's permission. And number two is that if you were to transfer the name into the trust, he will be incurring stamp duty because the trust is a different entity from him, right? So he has a trust, and what he do is that he and the wife will will the property upon their passing into the trust. So that's already using two different instruments. That's part of the wealth planning stage. Yeah. And then, of course, life insurance can come in a structure. So it just depends on how the life insurance will be used to help the planning. So some examples will be, let's say, if a client has 2 children and 1 house, how does he give the house fairly to the child or to both children, right? So for an example, let's say the house is worth $20 million and the older child, let's say, is a guy, married, moved out. The younger one's a daughter, still staying with the parents, and let's say both parents pass away. Now, if they were to just use a will to say that, hey, once I pass away, this house goes equally to my 2 child, right? The daughter is still staying there. She has no house of her own. Where can she move to? Can the brother say, yes, you can stay there? Definitely the brother can. But if she stays too long, the brother's spouse might be asking, hey, your sister is staying there rent-free. It's $10 million is yours. What are you doing? There's, we have that we might miss. So then you might need to force your sister to buy it from you, your half, or you get it to sell. And then there might be conflict, right? So where life insurance comes in is that, let's say, the father buys a life insurance on himself or the wife for $20 million, for example, right? And upon passing, the house goes to the daughter, the cash goes to the brother. So the brother gets cash, he's happy. The house goes to the daughter, she's happy. So that's a very, very basic way of how life insurance can come in with a will. Now, if you add a trust, another instrument that comes in, right? How you can do it is that you can, let's say, to buy a $20 million life insurance is too expensive, right? You can get something cheaper, let's say 5. Put it into a trust, put the property into the trust also, and have rules that states, okay, this house is held under trust for the next 5 years. After the 5th year, okay, the house is to be sold, with the children having the first right of refusal. And if they both don't want to buy it, then the house will be sold and the proceeds will be split equally. So how does it all come together is that, let's say the father initially bought a $5 million life insurance, right? The initial $2.5 million for the daughter can be used as a down payment for her own house. You know, and let's be honest, if in 5 years she still doesn't buy a house, then it's not, you know, it's her problem, right? She it's her fault that she didn't do it. But if she follows the rules, then yes, you know, this, by using just these 3 instruments, it makes total sense, because everyone is happy, everyone gets a fair share, and they do not incur additional cost. Yeah. So this is how we actually, or rather how I advise clients on using different instruments to estate plan. So I would say honestly, not every plan requires a trust.
Yes.
Not every plan requires a life insurance. So it just depends on what you want, what you envision your assets to where you envision your assets to go, how you want to be distributed, and that's where I point the right instruments for you to use. Yeah.
Absolutely. It's holistic planning, isn't it? Because everyone's situation is different. Same with wealth management. Not everyone needs the same solution, right? Because if you're retiring tomorrow, you might not want the same thing as if you're retiring in 30 years. So these things all kind of go together, which is why wealth management companies often work in tandem with lawyers and tax people and trust providers to find the right solution. So let's have just a few quick fire questions. So can crypto be held in a trust in Singapore?
No.
No. Okay.
At this moment, it's still a very big question mark. The bigger trust companies will not touch it yet because MES has still not given them the green light. But so far, to my understanding, is no.
Now, what is the minimum wealth threshold realistically, given the fees, to set up a trust in Singapore?
I think it really depends. So maybe I can go more into this, right? It's that there's basically, I will break it down to 2 kinds of trusts, very simply. There's the living trust. There's a living trust and the testamentary trust. So a testamentary trust starts when the person passes on. A living trust starts wherever the person wants it to start, right? Now, in a testamentary trust, the trust is inside the will. And this is probably one of the most common kind of trust nowadays because we must remember people pass away richer than when they are alive because of life insurance, right? So let's say if I'm just, you know, a middle class a person and I just buy an insurance of, let's say, $1 million, right? Obviously, I don't have that kind of money now, but it costs me about $1,000 a year. And let's say if I were to pass on in 2 years later, my family will get $1 million. So now in my will, I will write that the $1 million will be given periodically to my wife and to my child. Now that's a testamentary trust, right? So testamentary trust can be pretty affordable because the fees are being paid by the assets in the trust, and that can be roughly about maybe $2,000 to $3,000 a year, which they'll take from the assets, right? Okay, so that's the most affordable way of having a trust, the testamentary trust. Now, what's bad about that is that it's very simple. There's not much rules that you can place in it, so it's usually more for simple planning, right? But of course, when you're of higher net worth and you need something more sophisticated, that's where you have a living trust. Now, a living trust obviously has come with more costs because you're audited. The trust is always audited by MES and external auditors. So that will probably cost you between 15 to 20,000 US a year. So I would say that if you want to start a living trust, a good threshold that makes sense to me is about between maybe 4 to 5 million USD. Then it does make sense to start a living trust, because when you put money in the trust, I don't think you're just going to make the money stay there. You want to invest. So you want to be able to get investment returns that's able to afford to pay the trust.
Absolutely. Now that $15,000 to $20,000, does that include things like accounting fees for the company? Does that include everything, or just the trustee fees?
Everything,
okay.
yeah, everything.
Okay.
Yeah.
So just a few more quick fire questions then. What is the biggest single reason, would you say, why people set up trusts? In your case, in terms of your clients, even though we all know there could be 30 reasons, what would you say the one biggest reason is?
Surprisingly, I would dare to say that 90% of my clients will start up conversations with various reasons, but deep down, after talking to them and understanding them, the biggest reason is protection against the child's spouses. So basically the in-laws or outlaws, if you want to put it that way. Yeah. So that is quite a big reason. And in fact, I have a mentor in the US who I speak to sometimes. He's a business succession expert in US. And when I speak to him, his reasons in the US are the same. Protection against the child's future spouses. So it's something that we discuss, we like to share pointers, because sometimes we think that it might be a cultural thing. But we realize that when it comes to money, money supersedes all culture. Yeah.
And also, what would you say is the biggest mistake people make when it comes to trust? Like, for example, I would imagine some people maybe they don't think about it enough before setting up the trust. In other words, let's say you've got someone who has got 10 million in net worth and they've got a business that keeps ticking along, doing well. It might actually make more sense in some cases just to start with 5 million in the trust, keep more direct control with the other 5 million, rather than just going to 10 million straight away. Do you think that's a common mistake, or would you see other mistakes as being more prevalent?
Actually, I think that the biggest mistake someone can do is to not start a trust when they need to have a trust. Because a lot of them might be turned off by the cost of having a trust. To say that, hey, because the cost of $15,000 to $20,000 a year is just the accounting and the trustee fees, meaning that there's just your assets there. But if things can get more complicated, the amount might increase. So I can't tell you how much, because we don't know how much. It's very individual, right? But of course, the trustees will be very transparent before they do anything. But let's just even look at the base fee of $15,000 to $20,000. Some people find that it might be a waste of money, and they trust that they do not need this to look after the assets because they trust their children. But I always say that the cost of you not doing it might be even higher in the future. So that to me is actually the biggest mistake when it comes to not setting up a trust, right? I would say that for people that actually do set up a trust, I think it's important to understand that when you're setting up a trust, it's not something that we get the trust deed, we sign it on the spot, in 2 hours we are done, we have dinner. No. A trust deed, or rather an estate plan, is a journey. It's a journey with a very, very far destination. The reason I say that is because even when if you intend to set up a trust today, we need to talk about how your family is, the dynamics, and then you do your trust deed and your letter of wishes according to how things are now. But in 2 or 3 years later, we always have to revisit, has anything happened? Did any of your child get married? Any of your child had had their own child, the dynamics has changed. So we are always constantly changing the plan. So again, it's a little bit hard to make a mistake like that because, being a journey, if you take a wrong turn, you can just walk back and go back to the right path, because the destination is so far away, and the destination might not even be your death, because the destination is keeping the harmony within the family. So sometimes there are strategies which I use are even beyond having a trust, but the trust is just an instrument.